Okay, so I'm Alan Tannenbaum. I'm here with my partners, Salvatore Scro and John Lamole. I think Salvatore's here. So we are construction defect lawyers. We take associations through Central Florida, from Tampa Bay down to Naples, through turnovers, handle construction defect claims, financial claims. We've taken hundreds of groups through turnover. That's a major part of our practice, but we're going to be talking today about the other side of our practice, which is advising condominium and homeowner associations on major repair and renovation projects. And the topic for today is key elements in a repair contract can apply to a clubhouse renovation too. So it's not only repairs, but it's also renovations. The reason I mentioned the construction defect side is that when we get a call from a client about to take on a repair project, we take off our construction hat for a moment and put on our construction defect hat and say, well, before you jump into this project, are you a property whose buildings or improvements are less than 10 years old? And if so, we will ask the questions about, have you considered whether this is an original construction defect? There may be responsible parties who will pay for at least a portion of the repair costs that you're about to entail. So we will ask that question. The other possibility is you had a repair job done 2 years ago or 3 years ago, and the reason for your repair today is because that repair job failed. And we will then ask questions about whether there's a potential culpability or breach of a warranty coming out of the prior repair project. I want to mention that. That's a question that should be asked before you jump into things, because if there are culpable parties, you're going to look to issues like preserving evidence, putting them on notice, giving them an opportunity to inspect, all of those things in order to protect that type of claim. But beyond that, we're going to get into the central issue of the subject matter. And I just want to make sure, Salvador, are you there?
I am here. Okay,
well, the first topic that my partner Salvatore Scro is going to attack are detailed and on-target plans and specifications. And he's going to tell us why that's a key element if you're about to undertake a repair project, a key element to have in the contract.
All right. Good morning, everyone. My name's Sal Scro, and I'm going to take probably a little bit longer on this first part than the rest of the parts that we'll do today, and then they'll shorten up as we go through. But this is a pretty important part. I'm going to share a screen with you, and you'll see it's a little PowerPoint that I've put together. And let me just start this out. So can everybody see this slide here that says why this is important to you? I guess you can nod your heads and that'll be fine. So number one, you want to protect yourself. You also want points of direction for your client and your association. So a lot of responsibility is put on the board members and the managers, particularly the managers are looked at from the board to help lead them in the right direction. So a lot of the things you're going to hear today, we don't expect you to absolutely know everything about them, but at least you should have some knowledge to say you need to contact these particular people so that you can show that you're guiding your association and in the right direction. You don't want to take it on alone either. A lot of times people will look at one particular manager or board member and say, hey, you run with this. Well, running with it, the right thing to do in this situation is look to get help from the right professionals, whether it be engineers, attorneys, whatever, to make sure that you are in the best position possible to take on this task. You want to protect your client. So that's another you want to protect your client, your association, whoever you're working for, you want to protect them. You want to give them the benefit of your knowledge of these issues. And that's why you're here today, so that you can get a working knowledge of these issues. And then ultimately you want to successfully accomplish a task. So contracts, these are some of the different contracts you may want. One is with your design professionals. A lot of this depends on how big your project is. Uh, you may need a contract with your design professional, the engineer, the architect, whoever that may be. The contractor, obviously, you'll need a contract with your contractor. The owner representative, if you are going to be using an owner representative to help guide yourself through this, you may want to have a contract with that owner representative. And then sometimes your community association managers, they don't expect to take on these tasks, but they're saddled with them. So you may want to look at what is in the association manager's contract and what are they going to do? Is this part of their duties or not? Do you have to address those things? So those are some of the things. Why do you need a contract? You want to establish the job. What are they going to do? Define and detail the work, which is what we're going to get into, the target plans and specifications, and the clarity of those expectations. And also, when you have a contract, it's a disincentive to bad behavior. A lot of times you will say, hey, you're not supposed to do this, or you're supposed to show up at this particular time, or it was supposed to be done in this way, and it wasn't done. Why is that? You can point to the contract and have a reason why it wasn't. So you have a problem, whether it be because of age, defect, whatever it is. You want to find out what is it. You want to find out where is it, and you want to find out when did it occur. So those are the things you want to know. And why do you want to know when did it occur? Because you may have a cause of action against the party responsible for the defective condition, if it was a bad installation, if it was a code violation, whatever that may be. So who should you contact? So if you have a roof problem, you call and everybody can say it out loud. I can see your lips. You're going to call a roofer, right? If you have a window problem, you're calling somebody to take care of windows. And if you have a stucco problem, you call stucco. Everybody said the same thing, I'm sure. But I kind of disagree with all that. I don't think those are the people you call, because we don't know, and you're looking at me like this, but you do not know who that problem is. You need to know what or where the problem comes from. So a stucco problem could be a stucco poor installation. It could be bad flashing. It could be bad window installation. It could be bad framing. Case Allen had some years ago. They kept trying to repair the stucco. The biggest problem wasn't the stucco, it was the framing. So you need to know what to do. So to do a proper investigation, you should probably get the original plans and specifications of your project so that you know what you're looking at. You want to know if you had any prior work contracts so that you know what work had been done to the original work. And you do want to invest some money before you start doing work, especially the more detailed the project, the more money you may have to spend. And that may be that you need some destructive investigation, some destructive testing, so that you can identify what needs to be done so that you can prepare proper plans and specifications. I know Alan's used this example sometimes, where if you go to the doctor and they say, we don't know what's wrong with you, we're just going to start bring you in for an operation and start cutting you open. Well, that's really not the way to do that. They take tests, they take MRIs, they take x-rays, they do blood work. They want to know what they're doing before they start going after it. And why do you want to have destructive testing? The benefits of that investigation are this. You identify the extent of the defects. You identify who the responsible parties are. So if you're within statute of limitations period, which is 4 years from discovery, not to exceed 10 years from the work, those are your statutes of limitation and repose. You want to look and see in that investigation where the problems are. And if somebody was responsible for them, maybe you can have a cause of action against those people to address those issues and have them pay for your repair that you're about to undertake. You also need to know if you're going to do that, you're going to go after some parties, you're going to want to know what are these problems, because under Florida statute chapter 558, you need to give them a notice. So you need to give them a notice of what those problems are, and give it in reasonable detail so that before you commence any action to address that, sometimes you can settle it through that 558 process. Also, you limit change orders. Why do you want to limit change orders? And I showed this to you guys. Some of you may be in with me last time, but there's that big boat that says change order. There's the original contract. So you do want to get an idea of what has to be done so that they're not opening up your building and saying, geez, we just found this. We need a change order. That's where you're going to spend all your money. That's not part of your budget. You do not want that. So you want to have that investigation so you can know as much as possible. So you spend a little money up front, but it's going to save you money in the long run. So you limit change orders. You get detailed and on-target plans and specifications. You get a repair protocol from those experts. So they will tell your contractor exactly what needs to be done. That protocol will be set forth in plans and specifications that will be incorporated into the contract so that you will have a complete set of instructions. Just like if you buy something that has to be put together for your kids, you're going to have something that says how to put this together and how it's going to be done, what's going to be used. There's not going to be any questions if you have the right expert to provide those specifications. So that's pretty much just a summary, a quick summary that about why you would need detailed plans and specifications. There's other things that I'll get into later on about that relate to those plans and specifications, but we'll go on to the next topic.
All right, John, draw schedule. What is a draw schedule, and what do you mean in this category about it being balanced? Why is that important?
So one of the, hang on one second, because I think there's something I wanted to put up here. Okay. So time is money, right? And you want your project to get completed on time. And think about a contractor just like any other business owner, right? They come to work every day. They've got costs, they've got overhead, they've got payroll, they've got subcontractors to pay. And what are they in it for? They're in it for whatever it is, the profit that, whatever percentage of profit on your job that they're making, 15%, 20%, whatever it is. And so, like a lot of other business owners, a contractor wakes up every morning, a general contractor wakes up every morning, and he has to decide if he's got 5 or 6 different projects going at once, and that's probably the case, and maybe even more. He's got to decide, or she's got to decide, where am I going to put my people today? If it's a bigger project, like a big project where there would be a lot of subcontractors involved, a lot of different trades involved, that general contractor has to figure out which subcontractors am I going to have show up on this project today? And so all of those decisions are going to be impacted by whether or not that opportunity showing up on your job is going to provide that contractor with a profitable day, whether he's got risk in the project or not. This is an area where we have we spend a lot of time negotiating with contractors. When we represent community associations and we're looking at repair contracts, we spend a lot of time looking at the draw schedule. And the reason why that's so important is because you never want to be in a situation where the contractor has no risk on your project, where he's disincentivized to show up because he's already been paid the profit that he's going to earn on the job. And so maintaining or coming up with a very balanced draw schedule, a draw schedule that's going to basically delay that contractor getting his profit on the job until the end of the job, is critically important to getting the job completed on time. And you and your community association board not being those people sitting there in the orange vests waiting and waiting and waiting for the for the completion of the project. Deposits. A lot of contractors ask for deposits. We try to resist that. A lot of times you'll hear, I've heard many a general contractor that say that their deposit is their profit. Why would you give a general contractor the profit on this project right up front? So we would definitely urge, when we're looking at contracts, we would try to negotiate out any deposit up front for the work. And then finally, retainage at the end. It's always a good idea to hold some money back and at least hold back some portion of this contractor's profits so that they complete the work, including all punch lists. Because we've seen a lot of projects where basically the contractor's been paid. There's a lot of punch list things that need to be completed, and it just drags on and on and on and on. So, how it works with every contract is going to be a little bit different. There's no one size fits all, draw schedule. But that's an area where we definitely say, if you're doing it yourself, take a really good look at that, hard look at that, make sure that you're coming up with something that makes sense. But most times, get a lawyer involved, get us involved, or any other construction lawyer that has a lot of experience with dealing with draw schedules and ensuring that the contractor has risk on the project throughout the entirety of the project.
Yeah, and push your design professional. They'll usually create a draw schedule or have a comment on it, but you really have to push them to look carefully at it. I mean, what you want to avoid as a bottom line is the contractor having been paid 80% of the contract price and only 60% of the contract having been completed. You're going to be in a lot of trouble getting that contractor back to complete the job. We are also strong believers in retainage. The industry standard is 10%, so that 10% of the contract price is withheld until the time it's the final payment, which is a very strong incentive because the contractor's profit is going to be tied up in that 10%. So we're very strong believers in that. With deposits, they will tell you we need to purchase materials. If you happen to go along with that, just make sure that those are actually materials being purchased for your job and the contractor is not using it to pay their 90-day balance with their supply house for materials used on another job, or frankly, your materials make it somewhere else. So be careful with that. So I'm going to get into a couple topics about insurance requirements and damages for delay. A few things, and let's talk about the design professional first. Most design professionals will have $1 million of professional liability coverage. What they've been providing associations over the last few years are contracts that have limitations of liability that may say that the design professional is limited in liability to the amount of fees that they're paid on the job or some stated dollar amount significantly less than their insurance coverage. So when you get a design professional contract where they're going to be the design professional on a major repair that's maybe costing into the 7 figures, you don't want to limit their liability. You want it to at least be the amount of insurance coverage. And there's one issue. We've had projects that are $5 million, $6 million, $12 million with a liability policies of only $1 million. You can actually buy those coverages up to a greater level and increase the insurance coverage. So that's something that's available. But you want your contractor to have minimum insurance for general liability, for automobile, certainly automobile coverage. There are standard policy requirements. Really important that you negotiate to be the named insured under the insurance policy. Now, why is that important? It's important because you then have the right. You're now first party under that coverage, and if you had to eventually sue to collect damages under that insurance policy, under Florida statute, you're entitled to attorney's fees on a first party claim. So It's really important to be named insured. It gives you a lot of leverage against the insurance carrier to get a claim paid. And most of them will agree and negotiate that. So include that in your negotiations when you're looking at the insurance requirements. So damages for delay. Damages for delay typically sets forth a particular deadline for completion by the contractor. If they don't complete within that time period, there is a per day penalty for the contractor if it goes beyond the completion date. I think anybody who's contracting for work today, there's some contractors who are signing contracts to say, look, we won't even be able to start this job until September. So there's even a backup on initiation. So it's really important to have that damages for delay as a great incentive for the contractor to assign the subcontractors and personnel in order to get your job done. Just think of a general contracting company. They're taking on 5 jobs. They just started 5 jobs. And the question is, which of the jobs are they going to pay the greatest attention to, assign their better subcontractors to, assign their better superintendent to? They're going to be the jobs where there's a contract that they enter into that has some disincentives, as Sal indicated, against bad behavior. So if they have 5 jobs that they're starting and 2 of the jobs have penalties for late completion and the other 3 don't, and they have to make some very difficult decisions about assigning subcontractors and assigning personnel, the owner of the company is going to be very aware that this particular contract has things like damages for delay. So it's a penalty, but it incentivizes the contractor to actually get out and complete your particular project over projects that they won't. We see contracts every day that say there's no particular completion time, there's no penalty for late completion, and I'm always wondering a year and a half later when a group comes to us and says they haven't completed the job, and we look at it and says, well, there was no requirement that it completed within a stated period of time. You're going to be in a lot of trouble. So with that, Sal's going to cover a couple of topics: work inspection and rejection rights, and right to reject or replace subcontractors. That's how you have your speaker off. There you go.
All right. So work inspection and rejection rights. Who's going to inspect? That's what needs to be decided by the association. When you take on this repair project, who's going to inspect? Who can reject? And is that going to be the owner's representative? Is it going to be the engineer? Or would it be the architect? Those are some of the things that you need to decide. A lot of times you put the inspection rights into your engineer, or sometimes, depending on how minor the project might be, your owner's rep, your architect. But can they accept as well? Or should you have some right to do that? And should there be some reasonable time? So you need to make sure that you have enough time and that you have some control over your representative, whether that be the engineer or architect, whoever that is, so that if there's something that is not suiting what you intended and it's under the contract, that you can direct your representative to say, no, that is not acceptable. You need to do that. So the other thing is, if there's a problem, what do you do? Especially if you have multiple buildings. I've talked about this in other seminars we've put together. If you have multiple buildings, you may want to open that up to see what the problem is. If you're going building by building and you have some leaking going on, you may need to do some destructive testing again. Find out where that problem is so that you can identify, is this just a one-time problem? Is it a systemic problem that is in the plans that is not working out right? Well, what is it? What is that problem? So spend some money, have in your contract that if you need to open up something, that if it's their fault, they're going to pay for all that expense. If something that you've asked them to open up is unreasonable, then maybe you might have to eat that expense, but at least you know it. So you do want to have provisions in your contract for that, as far as who's inspecting, who's rejecting, and if there's a problem and you need to investigate it, what do you do? Also, when you hire these contractors, you're not just hiring the company, you're hiring whoever shows up that particular day. So you want to make sure that if you have a problem with the workers that are there, the superintendents, who are they? So the contractor typically decides who the superintendents are, who the subcontractors are. If you've had experience with other subcontractors in the past that you do not want on your project, you want to let your contractor, your general contractor, know that in advance. You also, if you have the right people reviewing your contracts, they may want to see. So for example, we deal with subcontractors every day. So we know what subcontractors' names we see all the time, and depends on how we see them. If we see them, in a litigation matter, then we know that we've seen them for these reasons. If we see them as repairs, then we know we've seen them for that reason. So you want to have some right to reject or replace your subcontractors, and a right to approve and or terminate the superintendent and those subcontractors. And let me just go back. We're not going to talk about prevailing party attorney's fees right now, but you do want to have the ability to have some control over who's being there. So I'm taking a little shorter time on this one because I went longer on the first one, but let's go on to, I think we're going to talk about protection against liens next.
Well, before John gets started, Sal, an issue that you brought up is really being a proactive owner. So it's your property. You want to have knowledge of actually who's walking towards your job every day to do work. So even before the contractor's entered into, you can have provisions in the contract that they have to give you the list of who's going to be the superintendent on your job, who are going to be the subcontractors. And if they choose to have somebody else, but that superintendent, those subcontractors, they have to notify you, and you have to be able to qualify those people again. Every contracting company that I've dealt with of any magnitude, they have, a handful of superintendents who have been with the company for 18, 20 years. They have vast experience. And then they have the guy they hired last week, a journeyman superintendent. They got a lot of work in, or one of their key superintendents retired. And now you're dealing with somebody that they don't even know very well, who's now assigned to your job. So it's a matter of qualifying them, and that being proactive, you have the right to insert that in the contract and be able to do that. So John, now you're going to tell us about protection against liens.
Well, I got to tell you how unenthused I was when I drew this topic, because, folks, I'm going to be honest with you. Even for lawyers, lien law is confusing, and so for managers, for boards, I can't stress enough how important it is to take the topic of protection against liens seriously. Here's a practical piece of advice before we get into some more details about liens. The practical piece of advice is that have somebody on your project, and whether it's the engineer, if you've got an engineer who did the design work, or you've got a construction consultant, but it always makes sense to have somebody who is tasked with ensuring that the work is, that any potential liens are avoided, released, protect your property from problems down the road with contractors and subcontractors, potential liens from that project. Your engineer, if you've got an engineer, if they provide that kind of construction management services, that you can pay them to do, then it makes every bit of sense in the world to do that. But let's talk about liens for a second in general. It's really a question of very dedicated management of the project's paperwork, okay? Because you want to make sure that there's a lot of different things that get, for example, you start a project, you need to absolutely make sure that you file a note or record a notice of commencement. You want to put the world on notice that there's a project, and protect yourself. That's the way that you protect yourself from potentially having to pay twice for the work. It also is a notice to any subcontractors on the job that if they want to have any lien rights, they've got to file notices to owner or serve you, the owner, with notices to owner. They've got to do that within 45 days of starting the work or providing the supplies. So recording the notice of commencement is the first step that you as the owner should do on any repair project. If you've got a bigger project and there's a lot of subs on that project, tell the contractor, ask the contractor, the general contractor, you want a list, you want to know who are the subcontractors and suppliers that they're going to be using, because you want to be able to anticipate, who may have potential liens. You want to keep track of whether those people have filed notices to owner again, or served you with notices to owner. In a contract, if you're negotiating the contract, things like that, like providing a list of the subcontractors and suppliers, are all things that could be put into the contract, could be requirements that you can negotiate into the contract. As the project goes forward, here's a mistake a lot of people make. I mean, it's just a common thing. I don't have to worry about liens if I pay, right? I paid what I was told to pay. So as long as I paid, I'm good. But you're paying, remember, you're paying a general contractor. You're not paying the 5, 10, 15 subcontractors who you have no contractual privity with. You're relying on that general contractor to pay those subcontractors and ensure that by you paying the general contractor, that you're not going to be exposed to liens from subcontractors. And so that's why it's critical to manage all of this paperwork. It can be confusing. And that's why you should always consider having somebody do that for you, somebody who's got a lot of experience doing that, whether it's the engineer, like I said, or some other consultant or project manager that's working just for you to do that. But every time you make a payment, you should be ensuring that you're getting a release or a partial release for that work. That release should be specifying the work that is being paid for and being released. It should specify what subcontractors are being paid for, or what subcontracted work is being paid for. You should be insisting on getting partial lien releases from those subcontractors or complete lien releases from those subcontractors. You should be knowing every time that you make a payment what work you're excluding from the potential of being liened. And that's just a day-to-day record-keeping type of thing that has to go on a project. Smaller projects, it's a little bit easier to do, but if you've got a big project, a lot of subcontractors, that can be a very confusing thing to do. All of these things, all of these requirements need to be specified in the contract, because if you don't, then you're just relying on the good faith of the contractor to do things that are going to, potentially help you ensure that you don't have liens on the project, but they have really no obligation to do. So you want to make sure that when you're negotiating this contract, you're anticipating all of those things that you want from that contractor to ensure that your project is paid for, not liened by him or any of his subcontractors or suppliers. And then as you go forward in the project, you've got to keep meticulously on top of that record keeping and all that paperwork. And that's it. I mean, there's really no trick to it. It's just being really, really proactive about, about organizing and maintaining those best practices.
If you want to really be proactive as an owner, within that 45-day time frame of a subcontractor providing work on the project, or a material supplier supplying materials, you get this notice to owner. I don't see any problem, unless it's prohibited by the contract, with making contact with that contractor who submitted that notice to owner or the material supplier and saying, I got your notice. And I'm very interested in you being paid everything you do under your contract. Please let us know if you're having any payment difficulties during the progress of the job, because we want to avoid the potential of you having enforcing a lien against our property. So, you know, a lot of general contractors will tell you, we don't want you talking to our subs and suppliers. And the standard response that I give is that, well, that's funny because they just sent me a note, and I'm a very, I have good manners, and somebody sends me a communication, I acknowledge the communication and say, thank you for sending this, and that line of communication has started. And again, at the end of the project, you need final releases of lien from all the parties who filed notices to owner. And you get something also called the contractor's final affidavit, which you must get before you issue the final payment to the contractor, which is an additional protection against liens. Okay, I'm going to talk about payment.
John, I just want to just say two things, because John reminded me of it, and you did also. But one of the things that would be nice to see in a contract when you're negotiating it is, if you have your general contractor, if he's going to hire subs, if you can require in your contract that any contract that the general contractor signs with a subcontractor, that you're identified as, the association's identified as a third-party beneficiary. Sometimes they'll do it, sometimes they won't, but it adds an added layer of protection, because now that subcontractor is contractually liable to you as well. Also, in the insurance that the general contractor has, I've seen it in some of them, but it's nice if their insurance policy insures the work of their subcontractors. Sometimes most of the time it will not insure the work, but if it does insure the work of the subcontractors, you have another added layer of protection there.
Thank you, Sal. Payment and performance bonds. Payment bond is a bond that protects the owner when the general contractor doesn't pay its subcontractors and material suppliers. That surety will come in under those circumstances and cover that bond, and the subcontractors only and the material suppliers only have rights against the bond rather than your property. So that's the advantage of having a payment bond, is that it removes the prospect of your property being lien. Performance bond, the surety agrees either to pay for the completion of the job or to provide you with another contractor to complete the job at the surety's cost. So it guarantees the performance of the contractor. So on a major repair project, we definitely recommend payment and performance bonds. There is a price to it. You know, roughly speaking, it's going to add 1% to the contract cost, depending on the particular contractor involved. So on a major project, if you have a $3.5 million project, you're talking about $30,000 of additional cost. But it's great to have the protection. But there's a underlying reason why there's a preference for payment and performance bonds. And the reason is the general contractor will never want you to have any communication with the surety and make any claim against that bond, because it not only affects your ability at their level of bonding capacity in the next year, but also the premiums that they would have to charge an owner, because part of the premium cost of a bond is based upon the amount of claims that were made against that particular contractor. So what I said before about delay damages, same holds true about having payment and performance bond as being a disincentive to bad behavior. Because if I'm a general contractor and I'm starting 5 projects, and again, 2 of them have a performance bond, and in particular, the other 3 don't. As the owner, I'm going to show up on the jobs that have bonds more, I'm going to, by nature, assign my best people to those jobs, because the last thing I want is that job to fall into default, the surety be contacted, and affect their bondability on jobs going into the next year. So that's a kind of a hidden reason why a bonded job, you're apt to actually get better performance. They're not going to risk not paying their subcontractors and having the surety contacted, which is going to affect their future ability to get work. So John, with that, spend a few moments on dispute resolution procedures. Why is that important? What does that mean?
Well, you hope that your job goes well and that there's no problems and you don't need to access the dispute resolution procedures, but that doesn't always happen. There can be problems that occur during, disputes or disagreements about how the work is being done that arise during the project, and then there are the big disagreements or disputes that arise after a project's completed, and perhaps you find out that it wasn't done quite the way that it should have been done. And so, it's really important that when you negotiate these contracts, you look at what do you need to do, or what are you going to be required to do in order to ultimately resolve a dispute with this contractor if it comes to that. Now, there are three things that you need to be looking for, because we see them in a lot of general contractors' contracts. The first is, where can I bring a claim if I have to bring a claim? Let's suppose we haven't resolved this thing, and I've got to bring a claim against the contractor, or vice versa. But let's assume you've paid the contractor, and it's really a question about defects in the work that was done, or defects in how it was designed, or the scope, or whatever. What you'll see a lot is a preference in the contract for avoiding circuit court and requiring you to arbitrate your dispute. And a lot of people have this mistaken idea that arbitration is better, faster, cheaper. And so, yeah, that sounds like a good idea. Why do I want to go to court? I'd rather go to an arbitrator. And I have to say that we typically don't like and recommend arbitration for construction disputes. It's not always cheaper. In fact, it rarely is cheaper. I mean, sometimes just the filing fees at the American Arbitration Association alone could be $5,000, $7,500, $10,000, depending upon the size of your claim. You pay a filing fee of $400 in circuit court. Don't ever forget that your project has not just you and the general contractor, but there may be other parties that are involved as well. There's a lot of subcontractors. And maybe you want to bring a claim against the subcontractor for their defective work, but you're not in contract with them. So you can't force them into arbitration. So if you want to bring a claim against the GC, you've got to go in arbitration. But if you want to bring claims against subcontractor too, you've got to have a separate action in circuit court. All of a sudden your expenses are exploding. And maybe the general contractor does have in his subcontracts arbitration. Maybe they bring those subs into the arbitration, but maybe they don't. You don't have necessarily any control over that. So circuit court is always preferable, because you can always bring your claims against everybody and anybody that's involved in that project in circuit court. You can't always do that if you're forced to go into arbitration. So arbitration, not always cheaper, definitely not as efficient, and a lot of times just as slow as circuit court. The other drawback of arbitration is that you don't get the same type of discovery that you get in circuit court. You have no set right to, take depositions, get documents, ask interrogatories, and all of those things that lawyers typically do in order to find out what the facts are and make the best case that they can for their client, in this case, you, the association. The other thing to look for, and what we typically find with general contracting contracts, is a preference for, if we do go to circuit court, you're waiving a jury. jury waivers, that's a case-by-case thing. But don't make that decision right at the front. Look, there may come a time in, if we're representing a client, we may say, hey, maybe we should not try this in front of a jury. Maybe it makes more sense to try this in front of a judge. But if you've already waived in the contract the right to try it in front of a jury, you don't get to make that decision. And a jury may be the best place, or your lawyer may think that that's the best fact finder for this case. You'd rather be in front of a jury. The other thing that we see and that you need to be aware of, and this can work to both parties' advantage, is prevailing parties' attorney's fees. So in America, under our system of law, unlike in some other parts of the country, the loser doesn't necessarily pay the winner's legal fees. It can happen if you contract to do that, or if there's some statute which requires you to do that. The lien law might be one area. But if you're just suing your contractor, if your contractor's done a really bad job and has done the work with all kinds of building code violations and other problems, if you don't have a contractual provision for prevailing parties' attorney's fees, you're not necessarily going to get attorney's fees if you win. So it cuts both ways, but we always recommend that you put a prevailing party attorney's fee provision in your contracts. So dispute.
And understand that the standard industry form contracts do not have prevailing party attorney's fees incorporated in them. So if somebody hands you an AIA or a AGC form contract, you actually have to add the provision of prevailing party attorney's fees.
That's correct. And the AIA contract has, kind of this built-in preference for arbitration. So be careful of that. We see the AIA contract being used more and more by contractors. It's got very, very confusing and frankly, onerous, during the job dispute resolution procedures. What do you have to do? Who do you have to bring it to? Who has to make a decision? Engineers, architects, everybody has to get involved in that. Those provisions aren't always conducive to getting the work done quickly. So, dispute resolution procedures, we could spend a lot of time on this, but the point is, if you see those things in your contract, think about them, run them by an attorney, and make sure you spend a lot of time in determining and negotiating how are we going to deal with situations that arise where we just can't agree and we've got a problem that needs to be resolved.
Tal, do you have anything else to offer on that topic? Because I want to answer a few questions.
Yeah, I just wanted to touch on a few things that I think are important in any contract that sometimes are overlooked, and I'll go through these real quick. So again, the prevailing party attorney's fees, John touched on, but that is an incentive to do well because of the risk of paying the fees. But it's a double-edged sword too. If you're not holding up your end of the bargain, you have to, you have that risk as well. And also it's an incentive to settle a weak case. But there are things that, and I'm not going to go into documenting the job, but or project closeout. But other terms that I think may be important in any contract would be hours of work. A lot of times, you hire them, you give them the deposit, they don't show up. Those are things that you may want to discuss, have in your contract. What days of work are they supposed to show up? The entrance and the use of the premises. How many people are going to show up on your project to work every day is an important thing to consider. Staging and storage areas. Who's going to maintain the materials? Where are they going to be staged, stored? How are they going to be protected? What happens if there's a storm? You need to address those things as well. Cleanup. That's an important thing as well. The cleanup, you want to make sure sometimes that they'll sweep the area for nails and things. You don't want, you want a magnetic sweep every day so your people aren't blowing tires, running over nails, things like that. Notice of work areas to your owners and the owner's access. If they have to shut down portions of access to the buildings, where will that be? and how is that going to be how's that going to be done? How much notice are your owners going to have if they can't use a portion of their building, and what is their access, and who's going to provide that access and the protective area for them? So those are just some of the things. And if you do have a litigation matter that may come up, you do not want to destroy evidence. You want to make sure that you notify your attorneys in advance so that they can make sure that parties are there to view what needs to be viewed, stored evidence, categorize evidence, things like that, photograph evidence. So those were just some of the things I wanted to touch on before we go to questions.
Let me raise the issue of assignability. I've seen this in some roofing contracts that have come across my desk. Make sure you have a provision in the contract that it can't be assigned, because there are companies out there, they're more like roofing marketing companies. They have fancy brochures, they have a big online presence, they sell roofing jobs, and then they assign them to other roofers to actually perform them. So you don't even know who's showing up on your job. So really important that you have a provision in the contract that says it's not assignable without your permission. So I want to cover a couple of questions. We have a short amount of time, and I know Michelle wants to do a poll. One of the questions is, what's the difference between a surety and a payment and performance bond? The surety is actually the entity that issues the payment and performance bond. So the surety is it's not an insurance policy. They're not an insurance company. They're a guarantor. So it's a guarantor agreement where they agree to come back behind the contractor and either agree to pay money that the contractor is obligated to pay its contractors and subcontractors and material suppliers, or come in and end up performing the project. I have a question about attorney's fees. How much does it cost for us to be involved in the contracting process? The first thing that we will do, because usually you'll be handed a proposed contract from the contractor for a fairly nominal charge, depending on the size of the contract, maybe between $500 and $750. We can go through what the contractor's provided and tell you what's in there that's going to come back to bite you, or what should be in there that should be there to protect you. And then you can come back to us and say, we want to revise this contract. We want some suggested language, which we can come back and do. But a lot of times, even on a relative, let's say a contract of $100,000, for a relatively modest amount of money, we can offer some suggestions that will can greatly improve that contract from the aspect of protecting you as an owner. And there's a contract that Amy has about gate security. Let's cover that offline. Okay, Michelle says I have to do the poll, so she's going to tell me how to do it.
Okay, so go to the bottom. I'll see it now.
She actually assigned me the role of doing the poll, and I'm going to let her do it.
It's not gonna work.
Okay.
We'll send it out.
All right, we're going to send the poll out because apparently that's not working. Are there any other questions? Because I want to respect everybody's time. And you can, if you have a particular question, you can unmute yourself. Paul asked a question about a $110,000 to $120,000 pool resurfacing contract. We do think a contract at that level justifies some level of attorney review to make sure you're protected. Should we consult with an engineer on a project like that? I think that's certainly enough of an expenditure to justify it. In the area of contracting, I would have to say, and I hope I don't insult any former pool contractors who may be on the call, but it's not the highest level of achievement in the pool contracting industry. So it's probably an area where you should have somebody knowledgeable out inspecting. There, it doesn't have to be an engineer. It could be somebody who was in the pool business for 40 years who now is a consultant. They're going to maybe cost less than an engineer, but at least it's somebody to have their eyes on the project. And again, when you talk about disincentive to bad behavior, a contractor who knows that somebody knowledgeable is going to be observing their work and at the time of the first draw is going to have the ability to reject it is really the greatest incentive for that contractor to get the best people on it, look carefully at the work that's going to be done.
You've frozen.
Yeah. The key is, and I'll conclude with this. I use this in my presentations. When you're contracting with a contracting company, pretend that you've just hired a group of 17-year-old boys to come to your project and do work, and think about the type of disincentives you would want in a contract to make sure those 17-year-old boys behave properly, and use that as a psychological basis for approaching the contract work. So want to thank everybody, at least the 99 people who got on, because I see that we had 99 participants, and I think because of the Zoom problems today, everybody above the 99 didn't get on the call or didn't get on the Zoom. We'll be dealing with all the managers on your certificates for today's session. Anybody have any other questions? You can provide us an email. I'll get your questions answered. For most major projects, we offer a free 1-hour consultation. A lot of what we end up doing is educating your board. For your managers, it's educating your boards on spending the money and time in order to protect themselves. It saves them a lot of money in the long run if they approach the job properly, have a good contract, and so forth. So thank you, everybody, for your participation. Hope you heard some things that were valuable for you today. Make sure in your engineering contracts that you look for those general conditions that limit liability and get rid of those. I've seen too many of those lately. And see everybody hopefully next month. So thank you, everybody.
All right.
Thank you.